Elections will be called order. Madam Secretary?
Thank you, Madam Chair. Chairman Johnson,
Present.
Vice Chairman DeSimone, Member Ettinger,
Here.
Member Connors,
Present.
Member Jack Foley,
Present.
Member Maderas, Member Scholes, Executive Director Miguel Nunez,
Present.
Legal Counsel Ray McCarthy.
Present.
Thank you, Madam Chair.
Is this mic work? Is it? Can you hear it through the mic? I can pull over David's, the light's on, but now? Okay, all right. Agenda item number 1, the board may discuss and vote to approve the minutes of the meeting of February 12th, 2025. Moved and seconded, all in favor signify by saying aye.
Aye.
Aye. The ayes have it. Agenda item number 2, the board may discuss and vote to approve the minutes of the meeting of February 20th, 2025.
Second.
Moved and seconded to approve the minutes of February 20th. All in favor signify by saying aye.
Aye.
And I will abstain because I was not here. Agenda item number 3, the board may discuss and vote upon the recommendations from the Legislative Committee on the attached election legislation to be submitted by the Board of Elections to the General Assembly for the 2025 legislative session. And I believe I'm turning it over to you, Madam Chair.
Yes, thank you, Chairman. So I know that it's in our package. It's item number 3. From our last subcommittee meeting, some of the next steps were after we received testimony from several groups, Ray, along with some wording from the Secretary of State's office, we were able to create different amendments. So I don't know if either Ray or Miguel want to speak to.
Do you want to start, Miguel, or do you want me to? I'll start on this one. Okay. So what was requested was that we come up with 2 additional provisions that define the terms agent and immediate family member. If you look at the document that's redlined before you, there is language to that effect, additional language requested by a legislative committee. So right underneath that, with respect to agent, that was fairly straightforward. There are no definitions of that term in Title 17, but we do have a regulation that defines that term, and I incorporated much of that language into this definition that was requested by the committee. And that comes from the regulation on independent expenditures. On immediate family member of the voter, as far as immediate family member, there is no definition anywhere in Title 17 on that regarding elections, nor in any regulations. So I instead just did a survey of different laws in our state, and this is a collection of them from less specific to more specific and broader. So we have those options that were also presented for the board to consider. So those 2 additions address the original legislation that Mr. Jack Gavoni had worked on and submitted to the committee for consideration. I should say that when I went over this, and I know that Mr. Jack Gavoni referenced his use of 2 other states, Connecticut and Massachusetts. I went to those states and I did some research. With respect to the Connecticut statute, which largely is used for this draft, there are several cases from the courts in Connecticut, one as recent as 2018 from the Supreme Court of Connecticut, that affirmed the actual language that Connecticut used. Now, before the court was not a constitutional challenge to the language, but it was under the lens of the court to look at its application, and it my recollections, there was no discussion of any kind of concern with the constitutionality of the provisions, which are the ones that we see with the original draft of this version that you had before you. So that's just information for you to at least consider. That basically is the modification to the original draft legislation. Then if you look at version 2, what I did in this one was basically just walk away from these type of details that you find in version number 1, trying to address some, maybe not completely, but some of the legitimate concerns that were expressed from some of the public interest groups. And that's the effort that you see here with the language with subsection F, as well as an alternative to subsection F. So this would be to basically, no person shall knowingly and willfully take any action to influence the intent of the voter during the voter's act of marking the mail ballot. So here we're trying to narrow when exactly there are restrictions. It doesn't focus any longer as on the presence in the room, near the voter, with the voter. It's more of when the voter is in the act of making that vote. That's the time when there should be no influence with that voter. I should say that both of these provisions, F as well as alternative F to version 2, were based upon my review of a case that came out from the district court, so the federal district court in Texas, about just several months ago in October of 2024. In that case, the U.S. District Court in Texas had reviewed a constitutional challenge to a statute that will be kind of similar to what we've been grappling with here. And expressed a lot of concern with some of the provisions. The language I've used here basically is pulled from those provisions from the statute that the federal court was satisfied with, finding them to be constitutionally firm, sound. So I use that as a basis for alternative version 2, both for F as well as alternative F. And then the last one for your consideration, this is basically just the use of what Rob Rock had written up as his proposal. I think he mentioned it during our last meeting with the committee, and then he sent an email to Miguel, I believe, and that language is his, and that's what you see for version number 3. So you have basically 3 different versions before you now for your discussion. And I believe there were comments from the ACLU, Common Cause, Disability Rights to each of these versions. We have that letter that could be made part of our meeting today. And of course, if the chair wishes, we could hear from them as well.
Oh, you're the chair.
You're the chair of the committee. Yes, I'm fine with that. If Kate and or John want to speak, and I was able to review the letter. Not sure if other board members were, but would love to hear.
Thank you for having us, John Marion from Common Cause, Rhode Island. I know Steve wanted to be here, but he said they're filing a lawsuit or something, which must mean it's Tuesday. So he couldn't be here, but I know he wanted to. And we wanted to kind of, we sent a single letter. I know last week we sent like 3 different letters, so we're trying to speak from the same hymnal here. And we tried to offer an alternative. So, our concern with all 3 is that it could potentially criminalize what we see as legitimate, behavior that might occur. And so we've thrown out some hypotheticals in the last week in our various letters, but, there could be, you could be with a friend or a family member, You could be discussing politics. They could be trying to convince you, hey, I think you should vote for this guy or this woman. And you then mark your mail ballot, and, under some of the proposed language that could be criminalized, and we don't think that should be. What we think should be criminalized is a person trying to, influence your vote in a way that they shouldn't be. And so ultimately, our letter, sorry, can I steal it? Suggests, settles on the term
Mhm.
intimidate,
Intimidation,
because
yeah.
we think that's the right word for what we're trying to capture. That campaigns, no one, whether it be your family or a campaign or a political party or anyone else in your life, should be intimidating you as you're trying to cast your vote. Influence, we just think, is too broad of term. That as a term, it may survive constitutional challenge, but we think it would criminalize behavior that really it's not meant to. If Kate wants to add anything.
I'll just add that if you think of the hypothetical, which has happened in my home and the homes of people that I know, everybody in the family requests a mail ballot, and you sit around the table and talk about it. And, what if somebody says, hey, what do you think about that question? And then someone pulls out their phone and says, well, what does the ACLU have to say about that one? And it's legitimate education and discussion, but yet under the reading of some of these provisions, that would now be criminal. So I think we've said clearly we understand the intent of regulating behavior that is questionable, but in doing so, we want to make sure that we're not casting the net too far toward criminalizing behavior that is healthy and appropriate.
Can I ask a clarifying question? So if we went with one of the other two versions, or so the version that the organization sort of pared down is like your second alternative F, sort of a sentence from
Modified.
there,
Mhm.
modified. Thank you. Are you saying that we wouldn't need the terms agent and family there?
I don't think
Because we're
so.
removing it completely.
Yeah, I don't think, I mean, it's intended instead to get more of a focus on a person who is taking some kind of inappropriate action.
Okay.
And
It makes it more broad.
limiting it to the agent of the candidate or the candidate, I just, in the second version, it was not seen as being necessary.
In some ways, it's broader. what
It-
we
it is broader.
proposed
It is
than
broader,
The
yeah.
first alternative, in the sense of who's regulated, right? So anybody who tries to intimidate, whether it's a family, whether it's a campaign,
Yeah.
whether it's a political party, can't intimidate.
It was intended to be very, very broad here, but it's as far as who might be in that universe of actors. But it was also intended to be extremely narrow as to when it would be applied, which is only in that process of marking the ballot. So it gets us away from really trying to decide proximity or anything of that nature. It's just while the person is marking the ballot, that's the sacrosanct moment when it's just the voter. All of the discussion, the people can be discussing everything. What does the ACLU think and all that? Have that discussion, you're fine. In that room, at that kitchen table. And then when that's done, the voter votes. And at that time, there's no influence. That's what the effort is.
Can we go back to version 2 for 1 second? Okay. Did you have something? Sorry.
Just to clarify for the witnesses, thank you for coming again, and I appreciate the input. At least the commentary you've given, or the the discussion we've had thus far is focused on a section that was added, I think, after the Secretary of State's office shared their version. The original language they sent to me is a little bit different, but that's notwithstanding. So just to be clear for the committee members that this is language that I didn't add. It really kind of is extending the intention of what I was originally going for when I introduced this. I certainly wouldn't, I understand and I share your concerns. I wouldn't want people to be just sitting around the table and then somebody, a family member saying, hey, look at this and try to, like, I could understand how that could be misconstrued, although I suspect it wouldn't be applied in that case. However, I wouldn't want to add that as a possibility. So I didn't include that. So if that whole section was not included, I would be okay with that, just for my own, feedback, because I could understand the concerns that could be misapplied, I suppose.
So for John and Kate, and just again, for version 2, you offered the suggestion that last sentence, it shall be unlawful for any person to intimidate a voter by word, sign, or gesture on how the voter should cast their mail ballot. Is that
So we think that standing on its own
on its own versus
versus either the
I just
the first or
clarifying.
second alternative
Yep.
would achieve what
We're needing to do.
Commissioner Jack Boney was trying to achieve, which is to criminalize someone who criminalize the behavior of trying to intimidate a person trying to cast a mail ballot.
Okay. Yes.
Sorry, just for
No, go
clarification.
ahead.
My focus was merely, I shouldn't say merely, but my focus was on the campaigns and agents of campaigns, whatever we define agent to be, not specifically on, criminalizing. So, because I feel like the federal law covers that already. I mean, someone could always go to the federal government if that happens today. Not that I certainly, again, I'm okay with what you've suggested, so I would be in support of changing it to what our witnesses have suggested. But to be clear, I was very focused on
The
campaigns
campaign.
and political activity.
Great. And yeah, I'm like, I
I
can't
know.
run this meeting.
No, I'm still absorbing, and I didn't, given what, you both said, are like, of those scenarios of, debating and talking with this statement, I guess the voter should cast their mail ballot. I'm going back to what you were saying, Ray, about like just playing that out, that, when it comes to the time, to actually mark the mail ballot, that's when the issue comes in. And I'm just wondering,
Right,
making
because,
sure this captures that, and to your point, doesn't make it wrong to, to have those conversations, and then thinking what the original intent of Commissioner Jack Boney's was, not to discourage that, but it's for it to be more based on campaigns or, candidate potential intimidation.
I think that's why I like the word intimidation instead
Yeah.
of just influence, because I didn't think of that, right? If you're technically influencing people by just talking about it. So I think the intimidation, there's like harm behind it.
Yeah.
So I agree with everything.
So, two thoughts. One is perhaps mark is a better term than cast. The other thought is, I don't think and I can't speak for Kate or Steve, but, this sentence we're suggesting doesn't sort of have a temporal aspect. Like it's not, you shouldn't intimidate somebody before they mark their ballot, as they're marking their ballot, after they're marking their ballot.
Mhm.
Like there should be no intimidation of
Ever.
the voter,
Yeah.
of the mail ballot voter. So if it could be written in a way that, is clear, I'm okay with trying to do that. If people think that this suggests there's like a temporal aspect, like it stops before the actual marking of the ballot.
Yeah, just Mark came in, and I'm, again, open to others, and particularly Ray, but Mark somehow puts a fine,
Yeah, I think we
Point.
use that in our language with version
Yeah.
2, and I agree with that. I agree with that. I think the intimidation is, as Mr. Jacoboni said, it's very different than what the legislation was originally intended to do, which is try to, in some ways, you can never replicate it, but try in some ways to create an insulation for the voter from influence in the act of voting that you see in a voting place.
Yeah.
So starting 50 feet out, there's a decompression time, a time where you just can think about what you want to do without the influence
Mhm.
of others. Because without that reference, and just having intimidation, you could have someone in a nursing home writing out their ballot, and the person who's going to be taking that ballot back and delivering it to the local, saying, Mrs. So-and-so, don't you forget, I mean, remember this, what we did here, that new sewer, that new rescue squad, all of these things can be said right as the person is writing out their ballot, marking their ballot. So it is further than what John is saying. It's meant to just go and provide that cocoon that replicates as best we can what you have in the voting booth.
Thanks, Ray.
May I make a comment? I just appreciate where everyone is coming from on all of this. I did notice that what you had just referenced was nursing homes and
Bad
ballots.
example, because we have,
Because in
we have a
nursing homes, we
bipartisan.
have guardrails
Yeah.
with 2 individuals overseeing. So
And
I
there's
just
a
wanted to
reason
know.
for that.
Right, okay.
And
so just-
I think that, we're trying to create that as much as we can. But you're right. So nursing home, we have the bipartisan, but in a home.
Yeah.
Of a person, elderly person, you could have that kind of influence.
Commissioner?
I just want to kind of back up a little bit and get your take on whether you feel that this is a necessary change in legislation. In one of your letters, Mr. Marion, you noted that we already have language in law 17/2030 that makes it a felony to deceive, coerce, or interfere with someone casting a ballot. I agree with that. So I find the intent to this to be redundant, and I'd like to get your take on it. I know we're debating version 1, 2, and 3, but do you feel that there's an actual need to debate this?
I think this would be in the mail ballot section of the statute, so it would be, applying, more locally to the mail ballot section, so maybe that, there is a need for that. As I said in the letter, that was last week's letter, I think 17, 20, 30 probably covers the sorts of things that Commissioner Jacoboni is trying to get at. There is also a second point, which is not my point, it's Steve's point, but I'll give voice to it, which is being careful not to create separate felonies that could both be charged at the same time for essentially the same action, that the legislature has tried to kind of get away, generally speaking, over in recent sessions from creating additional felonies for what's essentially the same crime. And there is a whole movement toward trying to not do that. That wasn't our point, that was ACLU's point. So yeah, I mean, I don't necessarily think this is needed, but if the board feels like there are additional safeguards, we're just trying to make sure that those safeguards are written in a way it doesn't criminalize what we think's legitimate behavior.
Or disenfranchise people
Yeah.
who are trying to exercise the right to vote.
So can I ask you the same question? Do you feel that there's a need to debate this, or do you feel like it's redundant and covered?
I think I'll join in John's response. I don't have really a different take from what he's already articulated.
And then at the beginning of your answer, you said something about the mail ballot section. I believe both of these would be in the mail
Oh,
ballot section.
yeah, sorry, 17, 20, 30 is, yep.
Right.
Yeah, so you're essentially, I guess you could say it's belt and suspenders, but I'm not sure how they would necessarily differ in application. Like if somebody came forward to you and said, I was trying to vote by mail and somebody intimidated me, and you made a referral to the Attorney General and the Attorney General tried to charge it, would they do it under what we proposed? Would they do it under 17, 20, 30? Would they do it under both? That would be up to the prosecutor. I don't necessarily see a true distinction between what we're proposing and what already exists. But I'm not an attorney, Ray's an attorney, Kate's an attorney.
Madam Chair, do you mind if I ask Commissioner Jack Boney the same question?
I do not
Do you
mind.
feel that Chapter 20-30 doesn't cover it? Or like the words, the language doesn't fully protect someone? I'm trying to understand that.
No, I agree with Mr. Marion that the new language that was inserted that I didn't include I think it is somewhat redundant with 17, 20, 30. I'm also not an attorney, just say that, so I'm not familiar with the dangers of a double felony and things like that. But I would just say, again, going back, Commissioner, to my original draft, which is specifically targeting is not the right word, but specifically looking at focus, thank you, on campaigns and their agents, et cetera. Well, there's a few more in there, but it was never meant to be general because I think that's covered elsewhere already. So
Any take on it?
No, I can't really add much more than what's already been expressed.
Can
Go
I ask
ahead.
one
Yeah,
more
of
question for
course.
Miguel? Without getting into specifics, I know this body has referred issues along these lines to the Attorney General. Have you heard of any cases where investigations have led to charges recently?
I'm not aware of any specific charges, but obviously over the years, anecdotally, there have been cases where there have been issues with mail ballots in certain municipalities, for example, where we have received complaints, for example. So that's something that if we do receive that, we refer them on to local law enforcement or to the state police.
I love these books, by the way. I'm just
They're
gonna-
really helpful.
They're really helpful. And to Commissioner Jack Boney's point, is there, and forgive me, because I'm flipping back and forth, is there anything in 17, 20, 30, or any previous that does speak specifically to campaigns or agents of campaigns?
Not specifically, no.
Says any person.
Right, it's broad and it restricts certain type of conduct, including coercion.
Go ahead.
I do have additional
Yeah.
questions, but
Yeah,
not
please.
specifically for the
No.
witnesses.
Go ahead.
They're welcome to stay in case they have any additional commentary. A couple things, Ray, on the two alternate Fs, the definition of immediate family member. There seems to be some semantic differences, but no differences in definition. Is that correct?
On the two definitions, one includes, I believe, adoptive relationships,
Okay.
So these were just extracted from different parts of the general laws. They are not from our Title 17, but yes, I just tried to give you some language from some other times that the General Assembly has defined these terms. So they are slightly different.
Sorry, thank you. So I think that, I mean, I would be personally in favor of the broader definition of immediate family to open it up to additional people within the person's circle of family. The other question I have is the word cohabitant, should that be included, perhaps maybe even section D, if we're considering that immediate family of the voter, comma, cohabitant, or
Mhm.
authorized by, I don't know if would be an official legal definition to find somewhere in Rhode Island state law, but it also then opens it up to if someone has a long-term roommate or a long-term partner, would also provide them an opportunity to help assist a voter who needs assistance.
We could do that. I mean, I think that other people who live in the household, whether they're, family members or not, I think there would be a reason to allow them to be in the room. Yeah.
Do you think cohabitant would cover that?
I think
Okay.
cohabitant would do that.
Okay. And then my final, again, my final commentary is just about my comment is that a lot of this came from I took a lot of I basically read the Connecticut statutes and distilled it down pretty significantly. And I did at one point, I think, share that with the board, the link to that. Theirs goes much, much further than this. I mean, the candidate can't even, or a campaign cannot even handle a ballot at any point, whether it's sealed, whatever. So they completely takes them out of the process. I thought this was much more of a modest proposal to say, they shouldn't be involved, at least when the candidate is voting. So that was my intention, just to be clear in non-legal, inelegant language. And I would just say, when we talk about an agent of a candidate, I do think we need to consider something of the volunteer, because a lot of candidates have a lot of volunteers, and long-term volunteers. They're completely excluded from this definition. It looks like they have to be paid. Anyone who's helped out a campaign in the past knows that there's a lot of unpaid people involved. So I think we need to, whether the word volunteer is on there, or we strike the word paid, that would be my proposal. I'm certainly happy to suggest language, but just for discussion purposes, I'll put that out there.
And so just also to clarify, we would only need the definitions if we're going with the some type of amended language, or not even, in the original proposal. If we used any of the others, we don't need the amendment. I mean,
No, because I don't believe the amended language, which
would
I
do
think-
what you
yeah.
were.
Well, wouldn't do
focused on
what we
doing.
want, what I was originally intending. I think it's redundant, and it doesn't use the words like immediate family or terms like that, or agent. So would not be necessary. This would be, of course, assuming we adopt D, and then we do want to define those specifically, so it's very clear what is meant by those definitions, by those words, rather. So I guess absent any further, I will make some suggestions. And I don't know if we're considering the original that I submitted.
Well, I think part of the discussion was we
Yeah.
were going to consider all the amendments or proposed amendments that were shared. And I think the part that we have to decide is, what do we want to move forward, if anything?
Okay.
I think that's the goal.
That's right.
Well, then I'm happy to, I think I have a few amendments, and I guess I'll make a motion to support this with the following amendments. Adopting D as I assume it appears on my paper and on the board there that I can't read, except to amend where it says immediate family of the voter and say comma cohabitant or authorized, so adding that. Adopting E as in I don't know what version this is, but the additional language requested by the legislative committee for the purposes of this section, agent or candidate that section and adding to that at the end, I suppose, or volunteer for the campaign, or just or volunteer, because I think campaign is adding for the campaign is redundant. And then since the alternate definition for immediate family F, the second one includes, is broader with adoptive relationships, I would suggest including that as well. And then finally, of course, I with the knowing and willful violation, the provision and the details there.
Sorry, can you repeat for F
Sure.
what you said?
It would be the second F.
Yeah, I apologize.
It's
I
not
can't.
there.
My
It's,
eyes
it's
are not
easier if
very
you read
good
it here,
at
Jenny.
Yeah,
in
so
your
I'll
paper?
read it just for the
Oh.
sake of
Where it
clarity.
says original proposal.
Yeah, so this would be, for the purposes of this section, the term immediate family or, immediate family of voters shall mean spouse, child, sibling, parent, grandparent, or grandchild, period. This includes step-parents, stepchildren, step-siblings, and adoptive relationships.
Do you all have any other comments? So sorry, I'm not following. The line around that was in this letter, which I think is a good one, that it shall be unlawful for any person or to intimidate a voter by word, sign, or gesture on how the voter should, and then I think we talked about changing it to mark their mail ballot. Where would that?
That wouldn't exist. According to his
That-
motion,
oh.
that wouldn't exist at all.
Okay.
That line, that's a good question. So basically, the motion that the commissioner made, we wouldn't add any of those sentences.
Okay.
Instead, D would exist because it focuses and outlines it in the candidate, political party,
Okay.
et cetera.
Okay, then I
It would
guess
be version, it would be version one.
Version one.
Version
yeah.
one.
Got
The
it.
original version one.
Sorry, forgive me.
Don't
Thank
be-
you.
Oh my God.
Then
that's
I
fine.
just want to make sure for, John and Kate, any reactions that, I want to make sure because I think your concerns and the constituents that, you represent are valid. So would any reactions to?
I mean, I think our letter last week and then the letter again this week speaks to our concerns about version one, and that even with the amendments that are being proposed right now, it could criminalize, behavior that, is not coercive, which is, I think what the intention is, right? Like, it's largely based on presence. And I get the idea of creating a zone, but somebody's mere presence in that zone could criminalize their behavior, even though they might not be trying to intimidate the voter into voting a certain way.
And I don't think I identified myself earlier, so I said Kate Bowden from
Thanks,
Disability
Kate.
Rights Rhode Island. I know you all know me, but our point in our letter last week was that this does not appear to be in sync with the federal and state right to have the assistant of your choice. So it appeared that it was setting up a situation where people in the polls have the right to whoever they choose for assistance if they need assistance based on disability. But yet, in the community, this seems to prohibit that same right on some level.
Can I ask Commissioner Giacofoni and Ray, so, because John and I just circled that really big, right? So the idea is and to both of you, it's the idea of somebody being present. That's the problem. So if some of the language that you shared in general, which again, and the chairwoman says she liked the intimidation portion, if instead of all these humans, unless authorized by law, are, intimidate a voter by, I really like the word sign and gesture. We're like, oh yeah, that's right. You can sort of point. Can we include that chunk of it into D to partly mitigate some of these issues? Because I agree, I think the idea of being present is part of the issue that not just them, but the Secretary of State's office also outlined. So if anything, I would say, I would ask Commissioner Giacone if he would consider a sort of removing present and including yet another part of a long sentence. Intimidate a voter by word, comma, sign, or gesture on how the voter should,
So to be clear, intimidation is bad, right? I think we can all agree on that. We don't
Yes.
need to vote on that. That was not, that
You
was
don't want them to
introduced
be
during the
there.
discussions of this
Okay.
at the legislative committee and,
Mhm.
and actually during the last meeting we had.
Mhm.
That was not where I was coming from with the original draft. So I think it does, and again, intimidation is clearly, if you read, well, as a non-attorney, me reading 17, 20, 30, you can't do that now. And that's bad and against the statute. So I don't think it adds anything. Personally, which is why it was not included. Intimidation obviously is bad. But again, I'll repeat what I said at the legislative committee last week, which is there's an inherent conflict of interest to a candidate, agent of a candidate, however we define it, handling a ballot. We're so careful once this ballot gets in, the mail ballot gets in the door here. And I understand the concerns about we're trying to make it somewhat equal in terms of coverage when we think about the polling place and at home or wherever they happen to be voting. We're not going to, as Ray pointed out last week, we're never going to get there because it's a completely different situation. So it's not just the voting of the I mean, if you bring in a candidate with you to vote at the polling place, they're not marking it for you because there's people there monitoring. They're not putting the ballot in, I would presume, unless you needed some sort of assistance, depending, I guess, on the type of assistance you needed. But it's a different situation, so it's not analogous. So I hope that answers your question.
It does, thank you so much.
You're welcome.
So is your issue with an agent of a campaign or candidate actually in handling the mail ballot, like, maybe bundling them together and dropping them in a box? Or is the intent of this to prevent someone from standing over and intimidating or coercion?
Because it reads as the second.
Yes,
Oh, not the
it
first
does
one.
read like the second. If you read Connecticut's, it goes much farther and does the first. But again, I was trying to propose something modest to get us into a point at least where we offer some security and protection related to, because this does, I mean, I thought about it and reviewed it with some people whose opinion I trust. And if somebody votes it at home
Mhm.
and then seals it up and they want to get it to either a mailbox, I'm sure,
Mhm.
they obviously individual circumstances differ. They may be able to get it to their own mailbox. They have a family member, but the candidate picking it up, again, I don't like that idea. A candidate or their campaign should not be handling ballots, in my opinion, but that's not what this does. Could it go further? Absolutely. But again, I was trying to start at some kind of modest compromise, thinking of some of the concerns that maybe brought up some of the more modest changes to offer protections to the election.
Yeah, the funny part is I think hearing you say that, I think one, you've mentioned that several times, but I think it was not finally now seeing all of it in front of me. I'm like, you're saying that goes really far. To me, that actually if we had written something that's very specific to someone handling in whatever words, fancy legal words we can measure that in, to me, that actually has more purpose than this. To me, when I read this doesn't go anywhere. Because I agree with them. I think the idea of being present is a really big slippery slope. To me, the being present is really, if we're going to criminalize somebody from being present, like that could be really dangerous.
So I'm sorry. So you're saying that being present is okay, but not handling the ballot is? I'm
No,
confused.
other way around. I actually think I would be really intrigued to read something that talks about that it's criminalizing or whatever, deterring from handling, because I think that's really interesting. I would rather read something like this. I actually think that the idea that this says present is a slippery slope. I don't think that this, when I'm reading this, I agree with like the opinions that have been coming up that this is just a slippery slope. But that's why I really liked the other focused versions until we found out that this already really exists. So I think that what we're having in front of us doesn't do much.
Just a question. So the handling is the language as it exists in the Connecticut statutes, but even if it's voted and sealed in an envelope, they can't handle that. So
No, I think that's
I
great.
think that goes
we-
even further than what I'm suggesting. So they couldn't be present, they couldn't,
Mhm.
I guess they could be present
Mhm.
in,
They could be
in
present,
your
but that-
scenario, you're saying
yeah.
being present. But once a person, then they leave and then the person seals it and they can't handle, I guess they don't
I thought you were
understand.
saying, because I agree that I don't want somebody from a campaign holding other people's mail ballots, handling it. Well, that's what I think of when you say handling.
Yes.
Yes, I
Voted,
can agree
sealed,
with
you
that.
mean,
Yeah, yeah, yeah.
everything.
I can agree with that. I can agree with that they shouldn't. But I don't think that this does that.
No, it doesn't.
Correct. So if that was the focus, then I don't know I guess what I'm trying to say is like, we're not really doing what you want to do because they can still handle it. I guess I'm sort of, I don't know if I'm going into a loop, but I don't know.
So
yeah.
if I may, through the chair, so what I'm hearing is you feel like this doesn't go far enough.
I don't know if that's a word. This doesn't do what you want it to do.
I think there should be additional protections, absolutely. But
Yes.
again, I was trying to start with something modest
Yeah, yeah.
that we could potentially all agree on.
Okay.
I think I'm similarly struggling. Like my mind is jumbled. We've had so much good discussion for all the right reasons, and I'm like
Mhm.
almost need to see something brand new in front of me. Sorry, Chairwoman, and also I wonder with embedding this in an existing law is not is there given the changes in the volume of voting in these different ways than we're here. I mean, is there new legislation? I don't know. I'm also not a lawyer or a lawmaker, but I don't know, I'm processing. So what's our timeline and what are
We're late in our
Option.
timeline.
our,
So there's a motion. We're late in our timeline. So we need to make a decision.
Well, there's
If
a
we're gonna
motion
get
on the
Yeah,
floor.
that's what I said.
If there's no
Yep.
second, then it would go nowhere. So I don't know if there's any other. I'll let my motion stand as it was made.
so if there's no second,
Yeah, the motion dies. If there is no second, then you can move on to see if there are other motions to be considered.
okay. There are other motions. So now what? Again, and
If there are no-
I agree, I agree with, at the end of the day, we're all coming to this from the perspective of protection for the voters from intimidation. I'm not ready to, I'm not fully grasping what's before us here and what just yet. But I do think that this conversation shouldn't
Mhm.
end here because, things could be happening that, and and people not coming forward, and we don't want that. We want to make sure that people have equal access to their own voice and their own choice. I don't know if anyone else wants to comment before we
Yeah.
move on.
Well, there should be a motion to, my recollection is, and Miguel, members of the committee can correct me, but my recollection is that Mr. DeSimone moved to advance this to the full board for consideration with these two definitions added in.
Mhm.
So it is something that was presented from the committee to the full board.
Yep.
I suggest, Madam Chair, that there be a consideration for motion to either accept or reject the proposed legislation so that there's something of finality to what's come up from your legislative committee up to this board for determination.
Fair point.
And if anyone has a different memory of that way that it came up, then,
Yeah, because I remember the commissioner saying to ask for the definitions and
be
some of-
added in.
Yes, and some of the amendments that were proposed. Mhm. Okay. I make, oh my God, this is a weird motion. So I make a motion to, say that again?
Well, either
What are my
to,
options?
either to adopt or reject
Okay.
the proposed legislation from the legislative committee with respect to the marking and certification of the ballot. That might be the best way to frame it.
So I make a motion to reject the 3 different proposals that we have in front of us to make these amendments.
I'll second the motion.
Okay, moved and seconded. Further discussion? And I do want to just thank Commissioner Jack Boney for the work that he put into this and state for the record that I do think this is something we should continue to discuss and explore, and certainly, owe the voters every protection. That's how we've always proceeded. And I think, again, all of us are on the same page on that. So, hearing nothing further, all in favor signify by saying aye.
Aye.
Any opposed?
No.
The ayes have it. Are we done with that?
We have,
Are you
you have a
done?
number
You-
4.
Oh, but did we finish number 3?
Yes.
Oh, so we voted on.
Thank you, John and Keith.
Thank you.
Thank you.
We
We
voted
just had-
upon all the other recommendations?
No, number 4 is their next
Oh,
recommendation.
sorry. Sorry, Madam Chair. Agenda item number 4, the board may discuss and vote upon the recommendations from the Legislative Committee for the Campaign Finance and Election Legislation submitted by other persons and entities to the General Assembly as described in the attached legislative summary during the current legislative term.
Thank you, Madam Chairwoman. So we looked at several pieces of legislation with the support of our executive director. And as you can see in the package, do they all have the same one I have? Okay. You will be able to see that several of the bills we took no position on. Those that you will see in red, we opposed, and those in green, we are in support of. There's also one bill actually that, because there was only 2 commissioners, we were split on the vote, so there was no action taken upon it.
So you
Yeah.
have that specialized
Oh, I'm
version?
sorry.
So
Got
you
it,
have
thank
to
you.
indicate the bill numbers for the support.
Got it. I'm so sorry. That's why I was like, does
Yeah.
everybody have not my key thing? Okay, never mind. Okay, perfect. I am going to tell you all those that we have no position on, if that's
I'm sorry,
okay.
do you mind just go, I think
Please
I've been trying to cross-reference the minutes to the Excel spreadsheet
Yep.
entitled to, just to see what you took no position, opposed, supported. It might be worth
Yeah, perfect. Yeah, 'cause
individually
you have
going
this.
through each
Yeah,
one.
absolutely.
So-
100%. So, Bill S-152, we took no position on. Bill 282, we were opposed. The reasoning is not all voters have driver's licenses or state ID numbers. Please stop me at any point if
We
anyone-
should just,
Oh, so sorry, please do.
if you have one motion at the end of this where
Mhm.
you basically adopt this, you're fine.
Okay.
It may get more complicated if you
Mhm.
take a different position, so just keep that in mind.
Perfect. Okay. So yeah, so I still should go.
Should we break them into the no position,
Okay, perfect.
support and?
If possible, and
Okay.
then if any board member wants to even carve out 1 or 2 from those, they can with a separate motion, but maybe that
Okay.
way you can have like one
chunk of
motion
it,
to adopt the position of
no
no
position.
no
Okay.
support or no position,
Beautiful.
rather.
Let's do that. Perfect. So delete everything you just went through your brain. Ready? So 152, no position. 283, no position. 288, no position. 5086, no position. 5232, no position. 5275, no position. 5276, no position. 5277, no position. 5383, no position. 5470, no position. 5519, no position. 5520, no position. 5538, no position.
Thank you. Do any commissioners have any questions, clarifications for the committee chair on any of the no positions? Yes, Commissioner Jack Voting.
I just have where the discussions regarding the ranked choice, there's a lot there.
Oh, yeah.
I don't want to rehash all those, but that makes me very concerned because it's something that I think
Keeps coming up.
it's something that requires a lot of study by this board prior to something like that occurring, because there's a lot of different municipalities and states and across the country have used it to varying success. So my preference would be for us to take a position against those. So if we could carve those out, at least to vote on those individually, and we could.
Okay.
I'm doing my best to try to find the
No.
ones that are all in that, but the rest of them I'm
Yeah.
okay with. I
Happy
just,
to, yeah.
yeah.
So we're pulling out S 152 for a separate.
There's
vote. Is that
several
what you're
actually.
saying? Okay,
It's,
go ahead.
Yeah.
H 5275, 5276. Sorry, bear with me for a second.
No, you're good.
And it's the first one, I think, 152.
5277 as
I think it's
well.
the first one, 152, Senate 152.
So then, Mr. Giacavone, perhaps a motion to
Extract them.
adopt the recommendation of the committee on all but those three, and then you could
It's
have a
actually
discussion
four
on
of them.
those three.
Sure.
It's actually 4 of them.
Oh, there are four, I'm
Yeah,
sorry.
so it's okay.
Whatever number there are, I thought
That's
there were
okay.
three, I
Yeah,
apologize.
no, it's okay. Yeah, so it's 152. It's 152 to 5275, 5276, 5277.
I feel like we're
Those are
playing
all
big.
ranked choice.
Those are all
On ranked choice.
Yep.
So 77 is actually just changing the primary system. It isn't ranked choice, it's just
Oh, yeah, you're right,
top
but-
two.
To us, it sounded like ranked choice. I'm so sorry. You're right. I apologize.
Unless the commission, if you wanted to carve that one out too, the 5277.
Sounds like ranked choice voting, but they're not putting it as ranked choice voting.
I feel like we're playing.
We are a bingo. It's a weird bingo.
Again, it's just to me, that 5277 is another flavor of ranked choice voting.
Thank you. That's
So I
what I
would like to
said.
include that one. Sorry, I'm trying to get all the numbers down. I apologize for making it so
Do you want me to
complicated.
read them
No,
again?
it's fine.
So we have 5276,
And 77,
77,
152,
that's Senate 152,
Yep.
yeah?
and then 5275.
So I'll make a motion to accept the recommendation of the committee of no position on all the ones with the exception of 5276, 5277, 5275 and Senate 152.
Okay. Yes, Commissioner.
Question. There was one that the subcommittee,
Oh, yeah, we'll go
Didn't
over
agree.
that one after.
but if the motion is all of them that have no position, that was included in that.
That's true. So one of them,
We-
yeah, so 5382, it's not that we don't have a position on, it's that we couldn't come to an agreement, so there was just no action taken on it. So should that one be part of what we're extracting? Or that one be on its own?
It's still no position, but.
Okay, yeah.
Sorry, I'll amend my motion to include 5382.
Thank you.
Thank you.
Thank you. So that'd be 5 total. It looks like
Yep.
4 House bills and 1 Senate bill.
There's a motion. I'm not repeating it. Do we have a second? Yes, Commissioner Connors, go for it.
I just want to clarify the motion. Your motion is to accept the recommendation of the legislative subcommittee on all bills that were voted no position,
Correct.
with the exception of
Those 5.
those listed, the ranked choice, and the one that.
No action.
Correct.
Okay, I'll second the motion.
Thank you. Moved and seconded. All in favor signify by saying aye.
Aye.
Any opposed? The ayes have it.
Can we vote first two on the, not, before we discuss those, can we vote
Sure.
on the rest of them
Sure
really
thing.
quickly?
Yes.
There was only one bill that we voted to oppose, and that is Senate 282. And the opposition, it was based on not all voters have Rhode Island driver's licenses or state identification numbers.
Any discussion on this recommendation?
You actually had one other as well.
Did I?
Opposed,
Oh my God, I didn't see it. I'm so sorry.
5137.
I amend my statement. Yes, 5137, we opposed it. While the Board of Elections has regulatory oversight of the central voter registration system, the Secretary of State maintains and manages the system and any database comparisons done with other federal and state databases. So the way the bill was written was just throwing us in there. We have nothing to do with it.
Thank you. Do I have a motion?
I'll make a motion that we agree and oppose those bills listed that the legislative subcommittee voted to oppose, including S 282 and H 5137.
Thank you, Commissioner. Move to
Oh,
accept,
do you-
oh, sorry.
Do we need to include, would you, because we might have to submit written testimony on this. Is there anything where you would like me to include in terms of that it doesn't apply to, the Board of Elections is not the body that
Yeah.
would implement this?
Yeah, I
It
think
should-
that some of the reasoning that you shared with us for both of them specifically, but specifically for 5137,
Okay.
please.
Do we have a second?
Second.
Moved and seconded to accept the subcommittee's recommendations on the pieces of legislation we opposed. Any final discussion? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? The ayes have it.
And we also supported two pieces of legislation. One of them was House Bill 5084. We supported early voting site. This is about having 50 feet buffer within early voting polling locations. They're not recognized under such as law, so this would treat early voting sites the same as election day polling places, offering voters the same protection from electioneering when they exercise their right to vote. And the next one is House Bill 5384. And this bill would increase the number of days from 7 to 9 days to request a recount. So the board supports this because it would provide additional days for candidates to request a recount. That is it.
Any questions for the chair on these two pieces? Legislation? Hearing none, do we have a motion?
I'll make a motion to accept the legislative committee's recommendations to, sorry, I'm looking for the bills now.
Oh, it's okay.
For
I
this
can
too.
tell them.
Thank you. Say that
It
again.
would be 5084 and 5384.
All right, so I'll make a motion to accept the legislative committee's recommendation on 5084 and 5384.
I'll second.
Thank you, Commissioner. Moved and seconded. Any final discussion? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? The ayes have it. And so now with we're going to take these the ones we extracted, one at a time to,
You could, or you could do all of the rank.
Ranked choice voting.
It's up
Yeah.
to
I'm-
whoever wants to address it, they can address it individually or by topic.
so we would start with the four that
Yeah.
are, okay,
Is it the
we'll
one?
take them all, yeah.
I think all of them,
Mhm.
I'd be happy to make a motion to not support. Not support 5276, 5277, 5275, 5382, as well as Senate 152.
Mhm.
I just think it is something that we would, I think, need to do a lot of study on before we implemented a ranked choice voting. I think that's generally what all of them revolve around, as well as changing the primary in a way. It just know the flavor to me of ranked choice. If we change the primary and anyone can run against anyone else. I actually, that one in particular, I think would be very bad for the voters of the state of Rhode Island, because that would severely limit choices. But either way, I think that it warrants a lot of study from this organization versus, coming out of the General Assembly. So to that end, I would say we should oppose that.
And I'm wondering if it would be helpful. So part of, during the subcommittee meeting, we heard from our executive director, who was actually part of the study commission, and shared a little bit about his and the board sort of ideas around it. So I don't know if you want to share a little bit about your thoughts.
Certainly. So in regards to ranked choice voting, our system does have the capability to support ranked choice voting. However, it's not native to the system. We would have to purchase a software product from a third-party company, essentially an open source software that we would load the results into to achieve the different ranks. So the voter would need to rank their first choice, second choice, third choice, and it's a decently complex method of avoiding a runoff election, essentially. So, and what happens is once we go through those certain rounds, each round, the winner is ultimately determined after whatever number of predetermined rounds that the regulations or the guidelines, I would assume that the board would establish based around that. The only concern that we had is other than the cost, that there would be a fiscal cost of purchasing the software from this vendor. It could potentially lead to a longer ballot in some instances, because if you've ever seen, and I just encourage you to Google a ranked choice ballot, it just essentially goes straight across the ballot from left to right. And we use a 3-column ballot, a 17-inch 3-column ballot. So you generally have your starting from top of the ticket on the left, and then moving over to the 3 columns and then onto the back of the ballot. Ranked choice goes across the ballot, so one office could potentially take up half of the first page, for example, almost. So that would push everything down and onto additional cards. So that means that we're more likely to have, for example, a primary with 2-page ballots, where we never have a 2-page ballot during a primary. And we're more than likely to have 3 or 4-page ballots in a general election, particularly in the bilingual communities, simply because those ballots have twice the amount of words on them. So they're just naturally longer. So Pawtucket, Providence, Central Falls, Woonsocket, they generally have 2-page ballots or 3-page ballots. That, again, that is not something that we would not be able to overcome. However, it does add to the logistical challenge of conducting the election, because the voting machines can only handle so many pieces of paper inside of them. So at a certain point, if every voter is getting 2 pages to their ballot, that's triple the amount of paper going in. That means that we either have to have more machines at those locations, or we have to potentially have more technicians to address any downtime, because triple the amount of paper going into a ballot machine leads to more potential jams and downtime to the machines. So in those aspects of it, it would introduce some challenges from the administration turn point to executing ranked choice voting. On the front end of that, also, there is significant educational or challenges that would happen, either between our office and the Secretary of State's office. Again, that's something that we would address if the law was passed. But from an administrative standpoint, we would face those challenges of acquiring the software, potentially having to purchase additional voting machines if that becomes an issue. We don't have enough to supply if we have 3 or 4-page ballots in some communities, and then also having enough technicians out there to address any downtime, so we don't have substantial lines or anything to that nature if there are problems or technical issues with the machines handling a higher volume of ballots. But technically, yes, we can support ranked choice voting in our current voting system as it is today.
That's what I was hopeful, because I didn't know the machine thing.
Go ahead.
Was there a motion?
Yeah, I'm
I
sorry,
don't
there
know.
was a
Sorry.
motion to oppose
Thank you.
those, the
Oh,
ones that I
thank
listed.
you. Thank you, yes,
That's okay,
sorry.
that's okay.
Yeah.
I will second the motion based on the logistical challenges that it would bring to us. I agree that more study needs to be made, but I'll second your motion.
Moved and seconded to oppose. Any other discussion?
I might not join the opposition, mostly not because I don't disagree with you. I agree. As someone who has like read this several times, the idea still confuses me. Part of why we took no position is, to me, it's still really frustrating. I think as the Board of Elections, to your point, I think being in the middle feels weird. If the no position feels weird. When I hear that logistically it can be difficult, but it's not impossible, it also feels in a way that like a responsibility of being like, well, we could do this if the people who make the laws can think through it.
Yeah.
Right. So, and I say that as several of the bills that we go through are like, oh, this has nothing to do with us really, just because elections are mentioned, but this has nothing to do with us, so we take no position. This is one bill that the technicalities of it come to this building, and we have just been informed this month for the first time that our month, whatever, this year, that for like, at least from my knowledge, that like our machines could do it if the people who make laws can clarify how to do it.
Yeah.
So that's what feels weird to me, because I agree with you. I don't like that we keep being no position on, but rejecting it, because I also know, being in both sides before being on this board, I also know how seriously we are taken when election bills are heard. And so I don't know if I feel great that the Board of Elections would be against the bill to do voting, to like sort of to vote or change the way that we vote. I was talking earlier about how when things like this happen, I always go back to, we should try this in a municipal level, but this doesn't seem to do that. I think we got to try things smaller before we do a whole state. So I think for that, those are some of my concerns, but I agree with you. I don't love that we keep taking no positions on it.
No, I was going to say something similar. I agree, wholeheartedly agree. We need further study and
Mhm.
discussion, because
Yep.
this has come up many of years.
Yeah.
But agree with all of your sentiments on this one. Any other final discussion before we vote? Okay, all in favor signify by saying aye.
Aye.
Any opposed? No.
Oh.
I'm a no too.
So no position.
So what is
So
that?
that happens,
Motion
no
doesn't
position.
carry. Motion doesn't carry.
Okay, so that means
So-
that they go back to having
So
no
now we-
You
position.
can go back to the previous position, or you can, as a board, think of another option, but this motion did not carry.
Mhm.
Is there another
Still,
motion?
we need
I
more
will
people.
make a motion to adopt the subcommittee's recommendation of no position based on the vote that we just took, which is basically us taking no position. There are issues that we need to study. We should look at it. I also appreciate your comments, because this feels more like a policy issue that we don't need to wade into. My take on it is logistically, it's a challenge and needs to be studied. That's why I made that second before. But my motion this time is to adopt the no position.
Moved to adopt no position. Do I have a second?
I would second, if we can, I think it would be important that when or if our executive director testifies or sends testimony, that what was shared with us today is also shared with the committees that are hearing it. I think that's important.
Yeah.
Again, to sort of be like, we have no position, but our machines could do this.
That's a really good point, and Miguel, for you not to, but I think if I remember correctly from previous years, you do make it a point to at least be there to listen in and or testify at elections-related bills that are from other entities, right?
for the sake of the record, I don't particularly agree. This might be a policy issue, but part of our mission is to
Yep.
the governance of elections. This would be a huge impact on the governance of elections. So I think we should have more of a say before something like this goes forward. But obviously, no position. You're not saying we're supporting it, but
Yeah.
just my comment there.
Thank you, Commissioner. A motion and a second. I think everyone has spoken. All in favor signify by saying aye.
Aye.
Any opposed?
No.
Yes.
Can I ask a
Yes.
question? So based on what the commissioner mentioned, this idea of studying it, this bill is going to keep coming like every year. And interestingly enough, it seems to have, again, even the very strange one, the 5277, that I also agree it's really weird and problematic. And so I'm wondering, our executive director has been part of study commissions, the state has done study commissions wide, but to Commissioner Giacomoni's point, what does that look like to be discussed in this house, right? Like in this building? To say this is gonna, I agree with the commissioner. I don't think that we can get away with much longer with not having a position.
Yeah.
And so I wonder if, it doesn't have to be now, it could be after legislative session, but I'm wondering if there could be room or space for having a conversation with members of the Board of Elections. If that's what Mr. Giacomoni is saying, that as a board, we need to study it, either this specific body or with staff members.
Yeah.
I'm just asking a question.
I agree. with
I'm
that.
not making more work. I'm just asking a question. If that's what you're saying, if part of what you're saying is, well, we need to study it, then otherwise you want to reject it every time. And I think that's a really real thing. What does that look like to do inside our house? I keep saying our house, but
Our
it's just the building, everybody.
To that point, I agree with that. It's a really good point. But question for Miguel is of this: what was the makeup of the commission that you served on?
There have been two. The most recent, the one I have more recollection of, was the last one was in 2017. This one was in last year. Was several senators, several representatives, Secretary of State's office, local board of canvassers, and essentially we just studied different. Ranked choice voting was one component. The top two, quote unquote, California style primaries. Was also studied, and it was essentially this past commission was more discussing plurality to changes to the Rhode Island's electoral system to ensure that the candidate who wins the election actually has more than 50% of the vote, whereas you have typically what we would have in a gubernatorial election in recent years is where you would have multiple candidates and the winning candidate does not achieve more than 50% of the vote. They may actually win the governorship with only 35% of the electoral vote of the votes cast. And also with the primary system, studying that to determine if getting more engagement, whereas primaries typically seem to determine the winner, the outcomes of the contest, where the general elections are a majority of the seats are unopposed, studying if there are different ways and methods in order to increase the probability that the candidates in the general election there will be more contests in the general election than there are now, where they're considered in the primary by a smaller percentage of the voters. So we had various presentations by professors, academics, actually from the state of Maine, came down to make presentations. I'm certainly happy to share the final report with the board that was issued. I'm not sure if perhaps I did. I don't believe I was the executive director at that time. So, and I can certainly share that document with you, and it's pretty well written and goes into the details of each of the pros and cons of each recommendation by the committee.
That'd be great.
Yeah, thank you.
Do we vote? We
No,
did,
we have
right?
one more bill.
Oh,
that
no,
we
but we
couldn't-
voted on this one. Yeah.
Yes.
Go ahead.
Yep. So we have one more bill that there was no decisions on, because we were split. So we,
You and Lou.
yes, it's, and as if you know this, you know that this is how we feel every time. So 5382, the act would allow citizens of a city or town who are at least 16 years of age to register to vote and to vote in a school committee election in municipalities where school committees are elected entities. So part of the reasons, and Ray, I don't want to speak for you, you shared a little bit, some concerns regarding the idea of the constitutionality of 16-year-olds voting, or anybody under 18 really. And another additional concern would be it would create separate ballot styles for certain voters, and anybody under 18 would need that. Commissioner DeSimone is not here. He is not in support of the legislation. I think it's an interesting legislation. Mostly because I like that it specifically focuses on school committees. As we know, people of school age are like school committees mandated. So that's where we found a split. Happy to discuss.
And this bill has come up for a couple of years
And
as
it's
well,
been
because I can
changed.
remember.
So before it was,
has-
they wanted to do statewide, and now they changed it, because you're right, this is before you were chair. And now they focused it only on town and municipalities to be specific to
That's
only
right.
school boards.
Yeah, that's
So
right.
they wouldn't be able to vote on a mayor, city council,
Okay.
whatever, only on school boards.
That's
So
right.
that's part of also why it creates a very specific ballot.
Okay, yeah, it's interesting. I would love to hear from Commissioner Jack Voney or Connors. I think it's interesting as a granddaughter of a 20-year school committee member in Warwick and someone who was civically engaged at a young age. I would have loved to have had the opportunity to vote, but I see some of the other challenges, but would love to hear more from either of you, if you have thoughts.
You mentioned some constitutionality. or something.
Right.
Yeah, so what I had said was that the people that are presenting this, the theory is that the requirement in the Rhode Island Constitution that you be 18 years of age is directory, that it would not preclude those necessarily below that age, but it certainly would require people over that age. It doesn't speak to people who are younger than 18. I view the constitutional provision as being mandatory, that it's saying exactly who, at what age you can vote, and only at that age. So you can't be 17 or 16. The construction, a rule of construction would be that it would be presumptively mandatory unless there's something in the language to say otherwise. I don't see anything in the language that makes me think that this is directory or just, so that's why I said to the committee that I think this would be subject to a constitutional challenge. It may survive it because a court could find that it is directory. We just don't have any case law from this state that speaks to that question.
Sir?
You don't have the language from the state constitution.
I did not bring it with me here today. I don't know if I could pull it up, but it's a mere one sentence, and it speaks to both residency and age to be a voter.
Sorry, did we get like explanations as what the thought process is behind any of these bills, or did we just get them as is? I don't know if we get any sort of.
What do you mean?
I
Like from
apologize,
the-
I haven't seen what I guess
Like the
you may
origin
be shocked
of
by
it.
this, but I don't see the reason, a need for this per
Oh,
se,
yeah.
but I guess I'd be interested to
yeah.
hear the arguments. I certainly am open-minded to hearing what people,
Yeah.
why.
I think the arguments, as I remember them when we talked
Mhm.
about it at length last year, was that young people have a vested interest and have educational, have at stake, if you will, for
Mhm.
lack of a better word, their education, and and I think we talked about also, or the justification and the origin of it was around, they can drive. There, you can get your license at 16, so you need to have a level of, maturity and mindfulness. And school committees are, there's a direct link and impact there. Commissioner Bettencourt, did
Yeah.
I?
No, that's really,
misspeak?
no, I think that's exactly it. And after the subcommittee, I also shared with Ray that there are actually several national organizations across the country that are working to sort of campaign around this. And it's been a lot more specific to being able to access voting to something that impacts them very directly, which is the school board. And so I like Vote 16 USA is one of them. There's several, and I think that there are other cities and towns that have across the country that have been doing this. So this is sort of a national campaign of why it's been done. And I remember again, like a year or two ago, when we were reviewing it, it was a larger scope, and they've definitely, I'm sure they've narrowed it down a lot.
Sorry, I didn't write down the things you said, but I'd love if you have
I have
access
it
to like those
twice, yeah.
links to those. I'd
Yeah.
love to read. I'd be interested to see what
Yeah,
the
yeah.
thought process is behind this.
Happy to.
Yes, Commissioner?
If you wish, I
Oh,
could just
right,
read.
sorry.
This is from Article 2. So it reads, "Every citizen of the United States of the age of 18 years or over who has had residence and home in this state for 30 days next preceding the time of voting, who has resided 30 days in the town or city from which such citizen desires to vote, and whose name shall be registered at least 30 days next preceding the time of voting as provided by law, shall have the right to vote for all offices to be elected and on all questions submitted to the electors." Then it goes on, "except that no person who has been lawfully adjudicated to be non compos mentis, et cetera." So there are restrictions. What I find interesting, though, is that the very last sentence says, "The General Assembly may provide by law for shorter state and local residence requirements to vote for electors for president and vice president of the United States." So in the Constitution, there's a carve-out for the General Assembly to modify these constitutional requirements under that last sentence, but only that. So I don't see why this is considered directory. I see it as mandatory that you have to be 18. But certainly if it was before a committee of the legislature, they would make that determination and decide whether to send it out of committee. If they thought it was constitutionally firm or infirm, they would make that assessment. That was just my reaction to seeing this legislation.
Thanks, Ray. Any other discussion? If not, does someone have a motion or wish to make a motion?
I'll make a motion to oppose or not support, whatever
Is it no
Sure.
position or not support?
not support.
Got it.
Oppose H 5382.
Move to oppose, a motion to oppose. Do we have a second?
At the risk of offending my soon-to-be 16-year-old daughter, based on the constitutionality, I will second the motion.
We're sending this recording to your 16-year-old.
Exactly, I want her, I would like her cell phone number. Moved and seconded to oppose. Any final discussion? All in favor signify by saying aye.
Aye.
No.
No.
No. That's great. So that takes us to no position. But now there's an action.
So are you making a motion to take no position?
I
Oh,
have to do that. Yes,
we
thank
have
you.
to-
I will
I
make,
think you should.
yes, I will
Yeah.
make a motion to take no position on 5382.
I will second.
moved and seconded to take, to take no position. All in favor signify by saying aye. Aye. Are you a no?
No.
You're a no. Okay. The ayes have it to take no position for the record. I didn't want to take us down that rabbit hole, but
Well, I would imagine if
I'd
we
like
didn't
to
pass,
see us
that's taking no position
I'd
just by
like to see
inaction,
us-
no?
Right.
That's right. Yeah.
It does help the director, though, if he's before a committee to be able to say what the vote was.
And that takes us
And
to the end of all
takes
of the
us to
bills
the
that were in front of us for
Great
now.
job, Chairwoman.
Thank
And
you,
just
everybody.
before we conclude, want to say again, we've been doing this for 2 years now. I remember when it was initiated, and I know a lot of work goes into it for the staff to
Mhm.
prepare us to have the discussions and for, our friends in the advocacy world and cities, and just a lot of work goes into it, including, us being able to review it. But I've said before, I think it's incredibly important that we're, actively engaged in talking about all things elections. And again, Miguel, appreciate you that you're always willing to show up and represent us in the best way possible. So thanks, everyone. And do we have a motion to adjourn?
So
So
moved.
moved.
Moved
Second.
and seconded. All in favor signify by saying aye.
Aye.
Assuming no opposed. So we are adjourned at 3:32 PM. Thank you, everyone.
Thank you.